BYJU'S Exam Prep brings to you the first All India Open Mock Test from 23rd of September to the 2nd of October. Go ahead and register now in the BYJU'S Exam Prep app and compete against thousands of
to
aspirants.
All of you friends, a very warm and a hearty welcome to all of you. On behalf of BYJU'S Exam Prep, the most comprehensive preparation app for all exams, I, Shurajit Bhaduri, take this privilege of having you guys to listen to me. Now, in this session, as we generally do, we bring to you the weekly roundabout of what have been going on in the courts in India. We bring to you these sessions wherein we talk to you about the important legal developments in India that are coming from the courts. Okay, so there are a lot of important orders, important judgments that are coming every day, and today we are going to talk about some of the most important and relevant judgments and orders that have come out from the courts in India. So guys, let's begin with the weekly legal current affairs for September 2022. This is part 3. Now, before we start, BYJU'S Exam Prep brings to you an All India Mega Mock Test for CLAT 2023. If you are preparing for CLAT 2023, BYJU'S Exam Prep brings to you an All India Mega Mock Test, which is to be conducted between 23rd of September to the 2nd of October. Get the real CLAT experience, and by giving this examination, or rather by giving this mock, you will get to know about your strength and your weaknesses, and you will also get to know how CLAT examination really is. Now, we have heard about CLAT, but we haven't given any mock test. Now, once you sit for the mock test, you will get to know what is the experience like, so that you can identify the correct strategy for clearing and acing this particular entrance examination. So a very warm and a hearty welcome to each and every one of you watching me live on your favorite YouTube channel. So guys, let's get started. The Supreme Court of India is evolving. Since we are using mobile phone, laptops to read and write, similarly, the Supreme Court also is going to do something similar. Now, the usage of paper, the amount of paper that is used during hearing of a particular case is enormous amount. There's a huge amount of trees which are cut because of the use of paper. So the Supreme Court, the Constitution Bench, which will be deciding on very important issues, which is headed by Justice D.Y. Chandrachud, has said that this bench will become a green bench. That means there will be no papers, no pen in and around. Everybody will carry an iPad or a MacBook or a laptop, and the judges can also take advantage of the reformation in our system. Now, it is a long drawn process. For a number of years, the Supreme Court, the judges are trying to be paperless. They want to function without paper, because when paper is used, you are indirectly causing harm to the environment. To save the environment from filing huge lumps of paper, the Constitution Bench of Justice D.Y. Chandrachud, headed by Justice D.Y. Chandrachud, has said that it is not going to touch a single pen or a paper during the hearing. They are going to take notes, everything, but in an e-format. It has also asked lawyers not to bring any papers or any physical document. That's very important. So Constitution bench, which is headed by Justice D.Y. Chandrachud, has said that he has asked lawyers not to bring any kind of paper or any physical document insofar as the court hearings are concerned. Now, how can we change the system from pen to paper to an e-format? For this, the Supreme Court has said that the officials of the Supreme Court is going to train lawyers how to use technology. So, technology will play a very, very important role. Now, every one of you do not stay in Delhi. Since I stay in Delhi, but I can connect you from anywhere in the country because we have internet, we have technology with us. Now, with the help of technology, somebody in Uttar Pradesh, somebody in Maharashtra, somebody in Karnataka, somebody in Bihar can watch me live. So let us take the advantage of technology and move ahead. That is what is the Supreme Court trying to say. The 5-judge bench, which also comprises Justice M.R. Shah, Justice Krishna Murari, Justice Hima Kohli, and Justice P.S. Narasimha, will be deciding the dispute between the Delhi government and the union government. Now, the Delhi government says that we are the elected government, we should have some powers. The people of Delhi have elected Arvind Kejriwal, but the powers in Delhi is mostly exercised by the central government. Is that clear? The powers, insofar as the functioning of Delhi is concerned. Now, Delhi police comes under MHA, Ministry of Home Affairs. Now, except for building roads, building schools, some amount of infrastructure, Delhi government does not have any power. Now, the Delhi government is trying to challenge it in a court and saying that we are the elected government. The Delhi government happens to be the elected government. But as a result of, even though they are the people who have been chosen by the citizens of Delhi, they do not have the real power. They do not have the real power. So, this tussle between the union government as well as the Delhi government is a matter that is before the Constitution bench headed by Justice D.Y. Chandrachud. Now, this matter will be heard paperless. Okay, this will be a case in which both the sides, both the lawyers, all the judges will not use paper during the hearing. So that's a very, very important announcement. You should also know, and you should also become paperless to save our environment and the trees. Now, apart from the Delhi LG matter, that is the Delhi government versus the central government matter, this bench is also hearing cases relating to the Shiv Sena dispute, that is the Uddhav Thackeray Shiv Sena versus the Eknath Shinde Shiv Sena dispute. It is also going to talk about, it is also going to decide on Section 6A of the Citizenship Act, Citizenship Amendment Act, and it is also going to discuss about the benefits of reservation and nomination in Legislative Assembly. Now, these are certain very, very crucial matters that are pending before the court. And Justice D.Y. Chandrachud, who is heading this Constitution bench, has decided that he is going to decide all these matters, but paperless. It will be a green bench which will decide the case. So the Supreme Court has asked lawyers not to bring paper files or any other physical document. Whatever they want to produce to the court, they can just scan it and send it to the court in advance. Is that clear, every one of you? Am I clear to each and every one of you? Okay, moving on. Now, this particular green bench, a counsel expressed his difficulty insofar as using technology is concerned. Now, lawyers are also old. Now, if you ask a lawyer who is 60 years of age to suddenly forget what he was doing for the last 40 years and transform into paperless briefing, then it will be difficult. So one of the lawyers in the court said that he has difficulty using technology. Now, Justice M.R. Shah also said that we also got training, someday you have to start. So all the judges have been trained very recently by the courts, by the staffs of the court, by the officers of the court, how technology is going to help judges in transforming to the system of green bench. Okay. So it also said that if you can argue in court, you can easily adapt to this technology if that you needs. So that is what Justice Chandrachud in a very slighter mode said, that if you know how to argue, then knowing just technology is very simple. Just that you need to get yourself trained insofar as using these technologies are concerned. Moving on to the next important judgment rendered by the Supreme Court. The Supreme Court in Bajaj Allianz General Insurance versus Dhanraj has said that crop insurance is not like a commercial policy. The Supreme Court has upheld the Bombay High Court's order directing Bajaj Allianz to compensate the farmers under the Pradhan Mantri Fasal Bima Yojana. Now, there is this Pradhan Mantri Fasal Bima Yojana insofar as losses that are being caused to farmers during a bad harvest. Now, if the harvest is not good, the farmers suffer huge losses. Now, there is this Pradhan Mantri Fasal Bima Yojana whereby an assurance was given that in case farmers suffer any loss due to rainfall or other natural calamities, they would be sufficiently compensated. So this was an insurance company making a promise to the farmers that in case their harvest, they suffer a loss owing to the harvest, they would be sufficiently compensated. Now, it was stated by Bajaj Allianz that the company would be adversely affected because a huge amount of claims have come from the farmers owing to the poor harvest caused due to heavy rainfall. Now, because of the heavy rainfall that has been caused, a lot of loss was caused to the farmers and they had a very bad harvest. Now, these losses had to be compensated. So the lawyer, Bajaj Allianz, argued that if we have to compensate, it will adversely affect their financial condition. But the Supreme Court said, nothing doing, you have to compensate these poor farmers. You have to compensate these poor farmers. That is what the Supreme Court said, very categorically. Now, the Supreme Court also said that this is a human problem and not an ordinary commercial policy. You are treating it as a commercial policy. Crop insurance for farmers is of a very different nature and it affects the very existence of the farmers and their family. So, when we are talking about farmers to be compensated for a bad harvest owing to heavy rainfall, it is the duty of the insurance company. Now, what is an insurance company? You can take a fire insurance, you can take a house insurance, burglary insurance. Now, what is a fire insurance? Now, fire insurance simply means that in case fire is caused to my house, the insurance company is going to pay certain compensation to me. Now, I have paid my money. I have given my money to this insurance company every year that I'll give you 10,000 rupees, but provided in case my house catches fire, you are going to compensate me. Now, these poor farmers have all paid their EMIs to the insurance company as a policy matter. Now, in case they suffer from a loss, Bajaj Insurance just cannot say that, we will not give you any compensation, because if we give you compensation, our finances will go into the drain. Is that clear, everyone? Is that clear to each and every one of you? If you guys are enjoying this session, do press the like button, because these sessions are absolutely important for each and every one of you preparing for CLAT and other law entrance examination. So I request each and every one of you to pay a lot of attention to these very important sessions that we are conducting. So crop insurance is not a commercial policy. That is what the Supreme Court says. Now, when the farmers have bad harvest, it affects the existence of the farmers. Their family member get perished. They get, you must have heard about farmers committing suicide. Okay, so many farmers commit suicide. So this is something that is very important for each and every one of you to understand, friends. Okay, so guys, if you're liking this session, do press the like button so that we get encouraged by you. The next important judgment coming from the Supreme Court again. Now, water that runs from the Himalayas or from any other places. Now, water that runs from the mountains to the plains and then to the ocean, does that water belongs to anyone in particular? No, it does not belong to anyone. Now, water sharing. Now, water initially enters Uttarakhand, Punjab. Now, if from the Himalayas, you have the Himalayas in Himachal Pradesh, Uttarakhand mostly. The rivers in Jammu and Kashmir goes to Pakistan. So in India, the most of the waters that we have in the northern belt are all Himalayan water, Himalayan rivers. Now, from Himachal Pradesh, the water enters Punjab. From Uttarakhand, water enters Uttar Pradesh, some part in Delhi, and then travels. Now, please try to understand this. Now, if tomorrow the Punjab government tomorrow says whatever water is coming inside Punjab, we are not going to share it with anyone. That is wrong. You have to share the water, the river, with other state. Now, Punjab and Haryana has this long term dispute between each other relating to the Sutlej Yamuna link canal. There is a dispute insofar as the Sutlej Yamuna canal is concerned. Now, as you know that Yamuna is getting dry and dried every day. Now, today's, if you go to Yamuna bank, which is in Delhi, you will see that it is nothing. It's worse off than the drain. Okay, it's worse off. Now, here is a dispute that is going on between the two states for a long period of time. It has been going on for a long period of time. So the Supreme Court said either Punjab and Haryana sit together or the court will order. Now, these issues, these water disputes have to be resolved. Okay, these issues are required to be resolved by the state governments. Now, it is no point bringing these kind of disputes to the courts. It is no point bringing all these kind of disputes to the courts. So the court over here becomes a little angry and said that what are you two states doing, Punjab and Haryana? There is a dispute relating to this Yamuna Sutlej canal. Sit together, talk to each other, or else we are going to execute the decree that we have passed earlier relating to sharing of water. Now, just because Sutlej is a great river, it brings a lot of fertility to the land in Punjab, Just because it brings a lot of water to Punjab, it does not mean that Punjab can just enjoy the entire water themselves. What will Delhi, what will Uttar Pradesh do? There has to be a link between the Sutlej and the Yamuna Canal so that water is distributed across India. It's very, very important. Okay, so the Supreme Court over here said that these issues should not be allowed to foster. It will allow forces that may not be amicable to the country to act and interfere. In this case, the Supreme Court was considering the sensitivity of the matter because this is a matter which relates to the larger interest of the people of the country. Okay, natural resource. So we are talking about some natural resources. Now, these natural resources are God gifted. These are natural products. Now, one state cannot say that I am just going to enjoy everything and I am not going to share the water with any other country. The same thing with Kaveri water, those Karnataka and Tamil Nadu, Maharashtra and all. So there is huge amount of this water dispute that is going on and on and on for a number of years. The Supreme Court is fed up. The Supreme Court now says enough is enough. Its water is a natural resource. We as living human beings must learn how to share such natural resource. Now, whether the water comes from Himachal Pradesh, so Himachal Pradesh tomorrow will say, I am not going to give even one single drop of water to Punjab. I am going to create huge dams. And tomorrow, if the dams break, Punjab will get flooded. Nothing is going to happen to Himachal. Can you do? Now, that cannot happen. These kind of things can never happen in a developing country like India. You cannot have states fighting against each other because they don't want to share water. Is that clear? Everyone? Every one of you. Am I clear? So guys, if you're liking this session, please press the like button. If you're liking this session, do press the like button. Okay. Can we move ahead? Can we move ahead? Did you understand what the Supreme Court did try to say? Did you all understand? Okay. Is that clear? Any doubt? Any doubt? Any doubt? Please let me know. Any doubt? Yes, Punjab is not sharing. They don't want that link between Yamuna and Sindh. They say that we will waste a lot of water and give it to Delhi, which where Yamuna flows. And once the link is made, then there will be less pollution in Delhi. Yes. Is that clear? Let's move ahead. The Supreme Court has finally granted interim bail to Teesta Setalwad, who was arrested after a two-judge bench judgment of the Supreme Court gave a clean chit to the then Chief Minister of Gujarat, Shri Narendra Modi. Now, Teesta Setalwad happens to be a social activist, and she stood against the state during the Godhra riots. Okay, now during the Ahmedabad Gujarat riots, she said that the police, the executive, everyone was involved, and hence these poor people from the minority community were killed and a lot of torture did happen. Now, there's a judgment of Justice A.M. Khanvilkar, which is up on review before the court, which says that Justice Khanvilkar, just before his retirement, has given this judgment wherein he categorically states that Srimati Teesta Setalwad was involved in fabricating certain documents relating to the Gujarat riots of 2002, and the police must take strict action against Teesta Setalwad. Now, the day the judgment was given, the very next day, she was staying in Mumbai. The Gujarat and crime branch, or the Gujarat police, went to Bombay to arrest her. Now, she was arrested in Mumbai. She was taken to Gujarat, and she was there in jail for more than 2 months. Now, the thing was this, that she was one of those social activists who raised her voice against the riots that was taking place in Gujarat during 2002. Now, during 2002 riots, we know what has happened, what has not happened. Let us not debate on it. Now, she was one of those people who went to the court and said that, something wrong is happening. Now, just because she came to the court and finally the Supreme Court held that nothing went wrong, gave a clean sheet to the present Prime Minister of India, the then Chief Minister of India, Shri Narendra Modi. Now, while doing so, the Supreme Court, in this particular judgment that was given by Justice Khanwilkar, and there are a lot of debates about this particular judgment. Now, based on this judgment, the Gujarat police arrested Teesta Setalwad. The matter was pending before the High Court and for a number of time. The Supreme Court finally held that bail is to be granted. Okay. Now, whether bail is to be granted or not depends on the law, depends on the acquisition, depends on the evidence, depends on the proof. Now, over here what we see is that whether bail should be given or not is a matter of law. The Supreme Court held that she is not tampering with the evidence. She has no power to tamper with the evidence if the case itself is over. She hasn't committed any such crimes where she should be in jail. So, while considering upon the standpoint whether a custody of the appellant must be insisted upon during the consideration of the matter. Now, in case some questions are to be asked, you can call Teesta Setalwad to the police station and she is going to answer. But keeping her in custody for 60 days, 70 days, that is not done, right? So Teesta Setalwad approached the Gujarat High Court. The Gujarat High Court refused her that interim bail, and she was and then she approached the Supreme Court. Now, very, very important thing, she was arrested on 26th of June in this year from Mumbai by the Gujarat Anti-Terrorist Squad. Okay, it was by the ATS Gujarat. The next day, there is a Supreme Court dismissed her petition that high state functionaries in Gujarat was involved in the conspiracy behind the Gujarat riot. So she said that the chief minister, high state functionaries were all involved during the Gujarat riot. Now, the case was dismissed. Since the day the case was dismissed, the very next day, the Gujarat ATS comes to Teesta Setalwad and arrests her. Now, this amounts to nothing but vendetta. Okay, so the Supreme Court was very aware of this thing, but the Supreme Court said, we are not going to do anything but grant her bail, interim bail. Till the time it is decided by the court that she is guilty, she is on bail. That is what we understand as interim bail. Manas Pandey. Okay, is that clear? Is that clear, every one of you? Is that clear to each and every one? So, the Supreme Court of India is absolutely conscious. Supreme Court of India is absolutely conscious of the fact that a clean sheet was given to the special SIT. Fair thought, no doubt. The Supreme Court says that Gujarat government was not involved in the crime. Fair thought. But does it mean that the day the judgment gets over, the very next day, the ATS Gujarat haunts someone? That's the question. Okay. Is that clear? Every one of you? Is that clear to each and every one of you? Okay. Brilliant. Fantastic. Okay. Great. So guys, before moving ahead, BYJU'S Exam Prep brings to you the All India Mega Mock for CLAT 2023, which is live between 23rd of September and 2nd of October. Get the real CLAT experience, know your strategy, know how to give this exam, because if you give this mock test, you get to know something more, and that is your strength and your weakness. Once you get to know about your strength, you can work on your weakness, right? It's absolutely important for everyone to know about their strength and weaknesses. So guys, do like this session, do comment, do share, and do subscribe. Do follow us on our Instagram channel, do follow us on our YouTube channel. I'm sure you guys, everyone are doing so. We are also there on Facebook, BYJU'S Exam Prep Law Entrance Exams. We are also there on the Telegram channel. Also, we are also there on Telegram. And do not forget to download the BYJU'S Exam Prep app. Once you download the BYJU'S Exam Prep app, you get a lot of videos, lot of material, lot of quizzes, lot of tests, and definitely this mock test. So guys, thank you very, very much. Have a great weekend ahead. Stay home, stay safe, stay healthy. Bye-bye. Take care. Good night. Thank you.